The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your frequently bi-weekly podcast on the Federal Courts of Appeals. I'm your host, John Ross, joined this week by IJ Senior Attorney Paul Sherman and the Director of IJ's Center for Judicial Engagement, Sheldon Gilbert. This week on the show, anonymous political speech, a post-SWAT raid code enforcement inspection, and license plate scanners. We'll start things off in the Second Circuit with Citizens United v. Schneiderman, who is New York State's Attorney General. The case involves a New York State law that requires nonprofits, if they're going to raise funds from New Yorkers, to register with the state and turn over their donor lists to the state, to the Attorney General. One particular nonprofit by the name of Citizens United is not pleased with this law and files suit. Paul, what's their beef?
Sure. Well, so probably everyone listening to the podcast has heard of Citizens United because of the famous 2010 Supreme Court decision, which was about whether corporations should be allowed to spend money on electoral speech. This case does not involve electoral speech. This is just about the ability of charities to fundraise. And traditionally, the Supreme Court has viewed that as First Amendment protected activity and has been very concerned about things that would burden that. But unfortunately, what we sort of have here is an example of campaign finance law swallowing other areas of First Amendment doctrine. Citizens United doesn't want to turn over a list of its donors to the state of New York. It doesn't think that there's any reason it should have to, because that's private information. And it doesn't raise any of the kind of corruption concerns that are present in campaign finance cases. But I think this gets to some more fundamental tensions that are happening in the case law here. And there's actually a question that came up during the rebuttal that I think goes directly to that. So we'll play that clip.
We'll play the clip from the oral argument, that is.
It seems to me there's a kind of oddness in your argument that the purpose of the First Amendment is to encourage and protect open discourse and speech. Everybody should be allowed to come and express their viewpoint openly without governmental interference, without retribution from the government, and so forth. What you're arguing for is the ability to do something which admittedly has come under the mantle of speech, but to do it secretly. Secret speech. I should be allowed to do secret advocacy and not let anybody find out about my exercise of my right to speak, because if they found out about my right to take positions and speak, they might dislike me and subject me to private taunts and private disapproval. There's a kind of oddness about the policy of the First Amendment to promote public, open discourse, and your position, which is that somebody should be allowed to do something that's called speech, but do it in secret so that no one finds out about it. What about that?
Paul, there's a lot to unpack there. What about it?
Yeah, well, so as you can tell from the judge's question, things were not going well for Citizens United, and ultimately Citizens United loses this case before the Second Circuit. The Second Circuit says it's fine to require you to disclose your donors to the state. There's really a lot going on with that question, though. So part of it is just, you can tell this general hostility to the notion that groups like Citizens United are even engaged in speech at all. Like the judge keeps talking about this idea that things that we have come to characterize as speech. And what he's discussing is like producing documentaries, or putting ads on television. These are things that are quintessentially communicative acts. It's not odd at all that those should be considered speech. And then the other thing that's going on is this increased hostility to anonymous speech, which has long been a part of public debate in America.
Yeah, you go back to the debate over whether or not the states should ratify and adopt the U.S. Constitution. And some of the most important speakers in that debate were speaking anonymously under pseudonyms like Publius in the Federalist Papers, which was a pseudonym for James Madison and Alexander Hamilton. Clearly the notion that speech can't be anonymous really doesn't fit with the history of our country.
Well, the Second Circuit does deal with a seminal case in that kind of vein, NAACP v. Alabama.
Yeah, so NAACP v. Alabama is a very famous case about whether the NAACP could be required to disclose its membership rolls to the state. This happened during the
civil rights era.
The civil rights era in the mid-20th century. And the Supreme Court in that case held that they could not be forced to disclose their donors. Citizens United tries to rely on this decision, and the Second Circuit, in line with the way the Supreme Court has treated NAACP v. Alabama, says absolutely not. We interpret that decision very narrowly. So unless you can show strong evidence that there's going to be violent physical reprisals against you, you do not get the protection of the NAACP v. Alabama decision. I think that's far too narrow a reading of that decision. And I think a lot of what's going on here, it highlights the difference between sort of a rights-based view of the First Amendment and a more instrumental view of the First Amendment. And I think this comes out in the judge's question, because he talks about the purpose of the First Amendment as being to promote this open dialogue and promote openness and get more information out there. And I think that's exactly wrong. I think that's one of the effects of the First Amendment. But the purpose of the First Amendment is to protect the right of people to speak as they see fit. And that includes the right to disclose or not disclose certain information about themselves. But what the First Amendment is not, and unfortunately what I think a lot of judges see it as, is a mandate to government to maximize the total amount of speech in society. And if you view it that way, then of course you're going to take the view that, yeah, we can require speakers to disclose anything we want that people might think is relevant about their identity. And I think that actually has some pretty chilling implications. I think it opens people to a lot of harassment. And I think it detracts from their ability to present their message in the way that they feel is the most persuasive. And that's why it should be considered a serious First Amendment problem.
Why does the Attorney General say that he needs access to these donor lists?
You know, the attorney, I think that's a really good question, because it goes to one of these threshold questions that the court has to grapple with, which is whether or not the regulation at issue is really targeting a particular type of speech. And the Attorney General says, well, hold on. This is a rule that applies to all nonprofit organizations, right? We're not picking political entities like Citizens United that are engaging in a particular type of political speech. We're not picking out conservative views or anything like that. We're just saying that we need to get this information from every charity in order for us to find and root out fraud. We don't want charities scamming donors, and if we have that information, we can help protect against that.
Yeah, I think there's two big problems with that argument, though. The first is that there's 47 other states that do not require you to turn over a list of your donors if you engage in charitable solicitation in the state. And there's no evidence that there's more fraud in those states. And the second problem is that these so-called anti-fraud concerns are really described at the absolute highest level of generality. Like, there's no real explanation for how these disclosures will genuinely help combat fraud.
And frankly, I just don't buy the Attorney General's claim that that's the real purpose behind these regulations at all. If you look at the way the Attorney General rolled out these regulations and other related regulations, the Attorney General doesn't talk about these in terms of general concerns about all nonprofits. The Attorney General talks specifically about nonprofits engaged in political speech and argues that unless he can have access to this information, he will be unable to root out dark money. Now, let me give you some quotes by the Attorney General Schneiderman about the topic. He says, when people spend money to try to influence our elections, the public needs to know the source of that money and how it's being spent. That's really important, because one of the Attorney General's arguments in this case is that the only person who's ever going to know these donors is me. I, the Attorney General, will have access to this information, but I'll keep it private, I'll keep it secret, and no one in the public is going to know about this, so you don't have anything to worry about. Trust me, right? But when he's talking about to the public the reasons for these regulations, he's saying the reason we need these is dark money is bad and the public ought to know where this money's coming from. And I don't really trust the AG's characterization of the purpose of the regulations. And what's troubling to me about the opinion is that the opinion itself doesn't really grapple with all of this other information about what's really going on here.
Yeah, well, and even if the information isn't being publicly disseminated, and there's definitely reason to be concerned that it will be. There's a similar lawsuit that was going on in California where they found that all of this supposedly private information was routinely being released. So that's a legitimate concern. But I think there's just something spooky and sinister about there being a government database of who is engaged in political advocacy. Like, even if that's only held by the government, that's a weird thing for the government to want to have. And it's perfectly reasonable for people to be concerned that if they're on that list, maybe they're going to be audited, or maybe they're going to be harassed over this, that, or the other thing. And when you've got these, highly political attorney generals who are looking to fight so-called dark money and looking to make a name for themselves, it's a perfectly legitimate concern. And I don't think the Second Circuit gives it nearly the credit that it deserves. So, overall, this is not a victory for the First Amendment, and it's certainly not an example of judicial engagement.
No, the next interesting question to me is what's going to happen next. And there are a bunch of different options for Citizens United, including going to the Supreme Court, asking the Supreme Court to review the Second Circuit's decision. And that takes us back to the last Citizens United decision by the U.S. Supreme Court. And we've talked about the piece of it that most people are familiar with, which is independent expenditures by corporations on political subjects. But another piece of that opinion dealt with disclosure regulations. And that's a case where Justice Scalia, the late Justice Scalia, was pretty vocal that he thought disclosure regulations complied with the First Amendment. I remember in the Doe versus Reed oral argument, Justice Scalia said something to the effect that, look, if you're going to participate in the political process, you have to have the courage of your convictions in a democracy and don't hide yourself. But now we're in a world where Justice Scalia has left the court. He's passed away, and he's been replaced by Justice Gorsuch. And I think a lot of people are wondering how Justice Gorsuch will tackle these questions. We don't have any opinion that's directly on point by Justice Gorsuch from his time on the 10th Circuit, but there are at least a couple decisions which I think suggest that Justice Gorsuch will be much more concerned about disclosure regulations than Justice Scalia was. When he was on the 10th Circuit, he wrote an opinion in a case called Van Deelen versus Johnson. This is a case about a sheriff who intimidated this guy during a meeting with a county appraiser, who then argued that this was a violation of his First Amendment right to petition government. And although it's not directly on point, Justice Gorsuch writes something in the opinion that I think is important. He says, when public officials feel free to wield the power of their office as weapons against those who question their decisions, they do damage not merely to the citizens in their sight, but also to the First Amendment liberty and the promise of equal treatment essential to the continuity of our democratic enterprise. And I think that that's exactly the concern that's at the heart of giving somebody like A.G. Schneiderman access to this donor information, is the concern that they will wield that to interfere with, a person's right to petition government, a person's right to as he says, question the decisions of government.
Mm-hmm. Yeah, and I think if this issue were to go up, it would be an interesting insight into the, Gorsuch describes himself as an originalist. I think it'd be an interesting insight into the kind of originalist he is, because Scalia described himself as an originalist, but he was very favorable towards disclosure. Justice Thomas describes himself as an originalist, and he is extremely skeptical of disclosure. And I think Thomas has the better view on this from a historical perspective. I think it's more consistent with the original meaning of the First Amendment. So if it goes up, I think it's going to be really interesting. Another thing that could happen here is that there have been discussions in Congress of just repealing the requirement that charities disclose to the IRS their donors. And if that happens, they're not going to have this forum to turn over to states like New York and California. And then it's going to be a question of whether those states are going to pass new legislation, separate legislation, to require those kinds of disclosures.
Well, that's an interesting point. So this donor list that Eric Schneiderman is asking for is just reproducing what Citizens United already has to give to the IRS. So, at some level, their donor lists are already being turned over to the government. It's just the federal government instead of the state government.
Yeah, and so what Citizens United argues in this case, well, so number one, at oral argument, Citizens United took the position that they think being forced to disclose their donors to the IRS is itself unconstitutional, and that they shouldn't also have to disclose it to New York. But they also think that there's just a different interest there that the Internal Revenue Service has in policing charities who have a federal charitable designation than the interest that the state has, particularly because the state wants to know all of their donors, even those donors who are not from New York.
One final point about this is that, even if you hate the Citizens United organization and or the Citizens United decision, there are reasons to be concerned about this because it cuts both ways. For instance, if you wanted to donate to an immigrant rights group, well, maybe you don't want your information with the IRS, given who's in charge of the federal government. Maybe you don't want your information with the state of Texas if Texas were to decide, that they were going to push a further anti-immigrant agenda, or however you want to say that. This is something that involves First Amendment principles and not so much the identity of the speaker. Okay, and now we'll move on to the next case, which comes out of the Eighth Circuit. It involves a SWAT raid. We've done lots of SWAT raids on this show. We've talked a lot about qualified immunity on this show, but this one's a little different. This SWAT raid involved a building inspector coming in and doing a code enforcement check right after a SWAT raid. Sheldon, tell us about this.
Yeah, so the police believed that a particular home had illegal drugs, illegal firearms, and other paraphernalia in it, and so they executed a SWAT raid. They throw, flashbangs into the house. They swoop in. They handcuff everybody, and by all accounts, they keep them handcuffed for up to 90 minutes. Well, it turns out that that in St. Louis there's a program that they call Project 87, and Project 87 provides a mechanism for the city to have code inspections piggyback off of SWAT raids. So whenever there's a SWAT raid, they'll also come in and see whether or not the house is up to code, right? And the SWAT officers in this case, they didn't have any reason to suspect that the particular home was not up to code, but nonetheless, they called in the code enforcement individual who comes in, and while the resident is handcuffed, the inspector says, "I want you to sign this form that says you voluntarily give me the right to inspect your home for code violations." Now, there's a little bit of a factual dispute here, but for the court's purposes, the court takes as true the residents' claim that the code inspector basically said, "Hey, if you don't sign this consent form, you could lose your home, right? Your home might be taken away from you.
And not just in the future, but right now.
But right now, right? And you're handcuffed. And so you really have to sign this form." So the guy says, "Fine, I'll sign the form," feeling like he doesn't really have any other choice.
So the family sues three different entities. They sue the police, they sue the city over the Project 87 program, and they sue the building inspector. The Eighth Circuit decision here only deals with the building inspector. The district court dismissed the case against the city, or against the police rather, and the case against the city is still pending. Paul, why is the building inspector, given that he's carrying out the city's ordinance, Project 87, why could he be on the hook for this?
Well, so he can be on the hook under the doctrine of qualified immunity if the constitutional right to not have a warrantless search of your house under these circumstances is clearly established. And so this is always the question in a qualified immunity case, is how clearly established is the right? And is it the case that any person who was in the building inspector's position should have known that this is a clearly established constitutional right? And I think this is one of those situations where the distance between what it's like to be a federal judge and what it's like to be an ordinary person out in the world really comes to the forefront, because this idea that people who are in this situation feel like they are voluntarily consenting to the search of their property, it just strikes me as utter madness. I don't know how anyone could look at that and think that, that's of course you would feel free to decline to have your house searched in this situation. But this is something that you see in a lot of cases where courts are looking into the reasonableness of government conduct. They just assume that people are just the complete masters of themselves at all times during their interactions with police and other enforcement officials. And I just don't think matches up with reality.
The other piece of this is that the court's looking at whether or not the building inspector reasonably believed that the search was constitutional, that the building inspector reasonably believed that he had actual consent, right? And the court says, well, it's not clearly established that if you threaten to take someone's home away right then while they're handcuffed, and force them to sign a paper immediately, it's not clearly established that every reasonable, building code inspector would understand that that's not real consent, right? Which is also, fairly laughable. I think that the building inspector pretty much understood exactly what he was doing when he forced the guy to sign the consent form under those circumstances and with the framing that he provided.
You wouldn't threaten somebody with taking away their home, with immediately condemning their home and forcing them to vacate, unless the purpose was to coerce them to comply with the search.
Especially when the building code inspector really concedes that there was no basis for suspecting that there were code violations in the home to begin with.
And I don't believe that he actually found any other than a window that the SWAT team broke. So, this is not a home that's falling down. It's not a home that, to look at it, you'd think, oh man, that house is in danger of endangering public safety.
Yeah. If there's a silver lining here, though, it's the concurrence by Judge Kelly, who is very clear that, look, we're letting the building inspector off the hook. We think the building inspector has qualified immunity. But these plaintiffs are still going to have the opportunity to demonstrate that this policy, this Project 87 policy of doing code enforcement inspections of every place that the police raid, might be unconstitutional. And I think there's very strong arguments that it is unconstitutional. So we'll obviously be following this case, and I think there's a good chance it'll make another appearance on this podcast.
The final case comes from the Kentucky Supreme Court. Listener Nick from Kansas City sent this to us, and we thought it was interesting. And Sheldon, why don't you tell us about it?
Yeah, so this is a fascinating case that really goes to the role that technology is going to have in future Fourth Amendment cases. The case involves a guy, Gregory Traft, who was driving around early one morning, and a deputy sheriff was driving in the opposite direction. And the sheriff had some equipment in his car that could automatically scan license plates and let him know if there was a warrant issued for the arrest of the person to whom the car was registered. So he drives past Mr. Traft, and bing, pops up that this guy's got a misdemeanor warrant and he failed to appear. So there's a warrant out for his arrest. So the cop turns around, goes after Mr. Traft, pulls him over. Turns out he's drunk, and so he arrests him for DUI. Mr. Traft tries to suppress the evidence. He says that the traffic stop itself was illegal, and that it violated the Fourth Amendment to rely on this automatic license plate reading technology. And the Kentucky Supreme Court unanimously disagrees and says, no, this is, you're out in public. You have no expectation of privacy. It's perfectly reasonable for the cops to use this technology, and you have no Fourth Amendment complaint whatsoever.
Yeah, they say this is the same thing as a police officer seeing your license plate, calling dispatch saying, hey, run this plate, and getting the response that, hey, there's a warrant out for the owner of the vehicle. So the only thing different than the usual scenario is it involves this technology.
Yeah, I think there's some additional context to what's going on here in addition to the technological angle to this that is important for listeners to understand. When we say that he had an outstanding warrant, a lot of people think that sounds like really scary, and he must have done something terrible if there's a warrant for his arrest, right? In this particular case, the outstanding warrant was because he failed to appear for a hearing that he had written a bad check. But in many circumstances, let me just talk a little bit about a case that the U.S. Supreme Court recently decided called Strife versus Utah. About the question whether or not, I call this the bored cop rule, whether or not a police officer can sit in his car and just as cars go by, check their license plates to see if they've got an outstanding warrant and then go arrest them or otherwise harass them, right? And it turns out from that case that this happens a lot, that cops really have nothing else to do, so they're just kind of actively looking for people with warrants out for their arrest. Now, in that case, there's a really interesting dissent by Justice Sotomayor. The Supreme Court majority held that there's nothing constitutionally suspect about that. But Justice Sotomayor provides a little bit more information about what it means to have a warrant out for you. And she says, look, there are at a minimum 7.8 million outstanding warrants right now in a federal database for minor offenses. And these are offenses like forgetting to pay a traffic ticket, right? So you forget to pay a traffic ticket and the court issues a warrant for your arrest for not paying your traffic ticket, right? So there's at least 7.8 million of these warrants out all over the place. Now, after the events in Ferguson, Missouri, research showed that 16,000 of the 21,000 residents of Ferguson had outstanding warrants for their arrest. In New Orleans, there are 20,000 arrests a year based on outstanding arrests for things like unpaid tickets. In Newark, New Jersey, the police stopped 52,000 pedestrians in a year, and of those 52,000, they ran checks on 39,000 of them to see if they had outstanding warrants. And the DOJ has said that by its estimates, 93% of those stops, of the original stop of the person, were completely unwarranted, and so you have warrantless searches. And the problem here, to me, about this case is that there is a huge possibility for abuse by virtue of the fact that there are so many warrants, outstanding warrants that kind of exist, and that all of the other protections that we have, however minimal they may be, against warrantless searches, by virtue of the fact that there are so many warrants for arrest out there, all those protections are kind of meaningless if you have the ability to use technology like this to automatically scan license plates and just find a reason to stop somebody.
Yeah, I think then the question becomes, is this really a Fourth Amendment problem, or is this a policy problem that needs to be addressed through some kind of legislation? Because, effectively what this technology does is it makes law enforcement cheaper, and, kind of basic supply and demand. If you make law enforcement cheaper, you're going to get more law enforcement. They're going to be arresting more people, and, maybe from a public policy perspective, we think that that's worth it. Or maybe we're creeped out by this, because I think this also raises questions about technology. And you forget license plate scanners. Think facial recognition technology. There's, I've used the word spooky a couple times in this podcast, but I think there is something spooky about the government just having cameras everywhere and knowing where you're going. And, if you happen to have a warrant, it pops up in a computer and then they come and arrest you.
Well, there are a few different policy responses to this problem, and one would be have fewer things that could trigger an outstanding warrant, right? It's not just the technological piece of this, but if you can, if a warrant can be issued for your arrest for forgetting to pay your parking ticket, maybe there's something wrong. And I do think that this rubs normal people the wrong way. So I mentioned that Supreme Court case, Strife versus Utah. Utah won that case, the bored cop case, where the cop can kind of just, run searches on anybody around him to try and find somebody with a warrant out for their arrest. Well, that rubbed a lot of people in Utah the wrong way. And as Paul suggested, there's actually pending legislation that would prohibit Utah police officers from doing just this, even if the Constitution allows it. So I think that's a piece of this. The other piece of this that I find troubling is, this other Supreme Court case called Arizona versus Evans that I call the incompetent clerk rule, right? And here's another problem with this huge database of warrants that are kind of hanging out there, is that a lot of that warrant data is just wrong. Those warrants have long since been quashed. And so in this Arizona versus Evans case, the cops find an outstanding warrant for this guy. They arrest him and they find marijuana on him. But it turns out that a clerk had just never bothered to update the record that warrant had been quashed, right? And the Supreme Court in that case said, no, that's okay. It's not the cop's fault that the clerk didn't update the database. And that might be right as a constitutional matter, but I think that we should be very concerned that you have these this kind of treasure trove of outstanding warrants that could be totally inaccurate, that are based on ticky-tack violations that can be used as a huge loophole to get around all of the other limitations on warrantless searches.
Yeah, I think one of the tensions in Fourth Amendment law that I've struggled with personally since law school is there's a lot of tools that I would not mind being in the police's toolkit if it's being used to catch like murderers and arsonists and rapists, but that I'm very concerned about if it's being used to catch people for misdemeanor amounts of marijuana or outstanding traffic tickets, or any of the zillion things that you can be arrested for that really shouldn't be crimes in the first place. And the best way to respond to that is not always clear.
Okay, that concludes the show. Thanks for listening, and be sure to tune in next time for more judicial engagement. Until then, this is John Ross from the Institute for Justice, accosting you to get engaged.